In Commonwealth versus Compel, the court again looks at a case of a claim of mistake of fact. Here in this case, the question was who had legal title to the horses in the stable. Now, in this case, the defendant had boarded his horses at the stable and apparently hadn't paid the fees to the stable owner. And so, at the end of the end of a certain time, the stable owner claims to have filed notice to proceed to sell these horses at public auction under something called a stable owner's lien, kind of like a mechanic's lien. That when you don't pay your mechanic for repairs done on your car, the mechanic can then has ownership of your car to the extent of the value of the repairs done upon the car. So if you've got a Lamborghini and had $5,000 worth of repair done on it, and the car is worth $100,000, probably more for a Lamborghini, but let's say $100,000, then the shop owner would be entitled to $5,000 out of the $100,000 value of the Lamborghini, but you can't just pull money out of a car or a horse. So what do you have to do? You've got to sell the property and then give part of the take your part and give the rest to the owner of the car or the horse. So in this case, the question was whether the stable owner had done everything necessary to perfect the stable owner's lien in the horse, and if so, then that would have defeated the right of the horse's otherwise owner to come and take the horse. But the question was whether the owner, whether the defendant in this case, was aware that the stable owner had taken these steps to perfect his lien on the horse and then sell it at public auction. If the horse's owner wasn't aware of that fact, then his going to claim the horse and is going to get the horse was just his reclaiming of the property. There was neither a larceny, not a taking, because there was no unlawful taking of the property, nor was there a burglary, because the entry into the stable would not have been for an unlawful purpose, because the taking of the horse would have been lawful. So even if the stable owner had perfected the lien, then the defendant would not have known about that, or had in good faith not known about that. Maybe he should have known, but in good faith he actually did not know that the lien had been perfected and he could no longer come and claim his horse. Then he still has this defense, and that is the good faith belief that it's still his property. That is a reasonable mistake of fact. And so this is a case in which if the facts were as the defendant believed them to be, he would not be committing a crime by going and collecting his horse. He also claims he's acted on the advice of an attorney, and depending on what he told the attorney, the reliance on an attorney's advice might further provide him cover in this prosecution. But the court doesn't get into the question of what the attorney was told, or specifically what the attorney told the defendant. But here again, a reasonable mistake of fact. He doesn't believe that the stable owner has perfected the lien, and so therefore he has every right to go and claim his horse.